Welcome. I'm Nancy Cahalan, President and CEO of Your Better Business Bureau. Welcome to our Business Builders Lunch and Learn webinar number 6 of 2023. Today we welcome Joseph Bartulis Jr. from Fletcher Tilton, and he's going to talk a bit about properly classifying your workers and avoiding some common mistakes that businesses make that can be very costly. Everyone will be muted during the presentation. I'll be monitoring the questions, so you can put them right into chat, and I believe there's a section for questions. I'll monitor both of those. If it's very pertinent to what Joe's talking about at that moment, I'll find a good time to interrupt, and if not, we'll hold the rest of the questions till the very end. All right, so without further ado, I'm going to turn it over to Joseph.
Good afternoon, everyone, and I thank you very much for coming today. So just very briefly about myself. I'm the chairperson of the Labor and Employment Practice Group at Fletcher Tilton. We're a law firm of approximately 60 attorneys with offices in Worcester, Framingham, Boston, Cape Cod, and Providence. And in my capacity as chairperson of the Labor and Employment Department, I help employers of all sizes on all issues that relate to employees. Now, I say labor and employment. Employment is what we're here to talk about today. Labor would be dealing with unions and all that comes with that. One of the things, or the thing that I'm going to be talking about today, and hopefully everybody's had their espresso or their Red Bull, because the topic can be dry. I admit that in advance. And if you are taking a nap during this, I'll try to remind everybody to wake up at the end of the remarks. But I jest. Okay. The issue is today that we're going to be covering in primary focus is classifying workers, right? Classifying people as either W-2 employees or alternatively as 1099 independent contractors. And I'm going to be walking through when you can do that, how you make the decision as to how to classify the worker, and what the fallout is if you don't properly classify the worker, and what you might be facing potentially. Okay, so I'm going to be kind of jumping around here. I will start by beginning my remarks by saying the issue is whether we classify a worker, right, as a W-2 employee, or whether we alternatively consider him or her as an independent contractor. Okay, so the first question people often ask, and it's almost obvious, but many employers will say, I'd like to use independent contractors, and is that possible? And selfishly, the reason they will often like to use independent contractors, right, is because independent contractors are not W-2 employees, and so all the panoply of laws, and I'll highlight most of them in the time we have today, do not apply to them because they don't work. They work for you. They provide services to you, but they are not your employee. Okay, so what are some of the reasons why things that you've got to be careful about classifying somebody as a worker? Okay, well, first of all, if you're going to have somebody working for you and he or she is being onboarded as an employee, the first thing as part of the onboarding process is they have to prove to you that they're eligible to work in the United States. They've got to, within their first couple of days working for you, prove to you that they're authorized to work here by showing you multiple forms of identification. And if they don't show those to you, you are not supposed to be employing them. Now, are the laws applied strictly or lax? It depends on who's in power and how strongly they're asserting this. But in a perfect world, right, where this was being applied to the letter of the law, if you're not authorized to work in the United States, or if one is not authorized to work in the United States, they shouldn't be brought on as a W-2 employee, right? So that's the first thing, is if you're going to pay them as an employee or have them as an employee, you've got to properly be authorized to employ them. So that's the first thing that comes up with being an employee. Another thing that comes up with being an employee is there are all kinds of administrative hurdles. So I'll just highlight these for you because this would also apply to anybody for whom you already have an employee relationship with that you're going to want to remain mindful of. and that is the Massachusetts Personnel Records Statute. If somebody is a W-2 employee, he or she must be have a personnel file maintained by your company. Now, what is the law that speaks to that? The law that speaks to that is Mass General Law, Chapter 149. 149, by the way, is a lot of the employment laws are in that chapter. Mass General Law is the moniker MGL. Chapter is where you can find it, what volume, and then the section would be the section. So section 52C of MGL Chapter 149 is the so-called personnel record. So we've already got to verify that they're eligible to work for us. We now have to maintain all the proper paperwork to verify that they can work for us. I have to make photocopies of that paperwork, and I need to put it where? In an employee personnel file. The employee personnel file needs to maintain the information of the employee's residence, right? His or her authorization to work for you. It would also usually contain, if it's direct deposit, it would have their bank and routing information, right? It would also have their job title, start date, end date if they leave. All of those things are in one's personnel file. Okay, you need to comply with that and have a personnel file on each of these employees. Now, real quickly, as it relates to personnel file, if the relationship with the employee goes sideways, the first thing employees tend to do, in my experience, is they will reach out to the employer and ask for a copy of their personnel file. It is a violation of the law if you don't maintain a personnel file for an employee, and that personnel file must state what their hours of work are, what their rates of pay are, all the key information that would allow the employee to determine whether or not he or she was properly paid. Why is the personnel file so important for you to have if they're an employee? The personnel file is very important because if they later claim that they were terminated and they were wrongfully terminated for discrimination, right? The attorney who's taken that case, often on contingency, is going to want to see what's in the personnel file, because the employer is purporting that the employee was terminated because they were perpetually tardy, right? Well, that may be true, but the employee may be, and this is an example I often give because it checks all the boxes, right? But it's if the employee happens to be a one-legged Eskimo woman over 40, right? She's over 40, so she's age protected. Eskimo descent, her national origin is protected, minority status, female status, and one-legged, she's disabled, right? She checks all the boxes. If you say that she was terminated because of her poor attitude or her perpetual tardiness, whatever the thing may be, she would ask for a copy of her personnel file. And in asking for the personnel file, she's looking for documents in there that substantiate your point that she was terminated for a bad work attitude. So what's the takeaway for you if they're an employee? If they're an employee who's working for you and you have deficiencies in their performance, you need to document, right? Because there's no such thing for an at-will employee to be wrongfully terminated. An at-will employee may be terminated for any reason or no reason by the employer, provided the employer is acting in good faith. And good faith is established by a non-discriminatory animus. So if I'm in a protected class and I believe that you're terminating the employee believes you're terminating him or her because of their one-legged Eskimo over 40 female condition, if you've got a personnel file that says they've been spoken to 5 times, right, or written up 5 times for being perpetually tardy, and the 4th one said if you do it again, you're going to be terminated, no attorney is likely to take that case because the personnel file is complete. The key for you is if the person is a W-2 employee, one of the things that happens, right, is 1, you got to maintain a personnel file. 2, they could sue you for discrimination. Wrongful termination doesn't necessarily apply, right? Doesn't necessarily apply if the person's an independent contractor. So I'm just going through with you, again, employee versus independent contractor and all the additional hurdles that one needs to jump through if the person's an employee. Now, as I say that, that would make the impression that I'm favoring independent contractors. I'm not. Many employers would love to use independent contractors because they don't have to comply with any of the things I'm telling you about now. The problem is Massachusetts recognizes that. So I'll be dovetailing into my discussion. when you can use independent contractors, and what hurdles need to be met for an employee to actually be an independent contractor. Okay, so I've mentioned the personnel records law. Now, if an employee comes to you and says, I would like a copy of my personnel file, the law requires that if they've been terminated, they have a right to get access to it right away. If they can request it at any time after they've been terminated. If they're your employee, or even if they've been terminated and you get the request for the personnel file, you're obligated to provide it within 5 business days of when the request is made. Now, what you'll often get is you'll have some ambulance chaser attorney who may be representing this person seeking a copy of their personnel file, and they'll reach out and say, send me Susie's personnel file. My suggestion is that you don't respond to that. You basically say, who are you? And I'm not giving Susie's personnel file to a third party unless Susie has signed an authorization, which often comes attached to the letter from the attorney. So if you get a letter from an attorney asking for the personnel file, you will of course provide it. If there is a letter from Susie saying you could do it. Okay, next, what else happens if you have an employee versus an independent contractor? And this is really where the rubber meets the road, right? This is in the area of having to comply with all wage and hour laws in Massachusetts and federally that apply to employees. Independent contractors are not your employees, so you're absolved from having to comply with all of these employee laws that I'm going to mention here. So the first law that I want to point out to you that apply to employees, because if you, and I'm pointing all these out, you understand, because if you misclassify somebody as an independent contractor who in the fullness of time couldn't have been an independent contractor, all of these things will come to haunt you because you will be vulnerable on each of these fronts that I'm mentioning now. So if you didn't properly document when they came on board, that could be an issue. If you didn't maintain a personnel file, failure to maintain that is an issue. If you failed to keep accurate payroll and wage records for your independent contractor, who in hindsight now in the fullness of time is now being recharacterized as a W-2 employee, or should have been initially, you've got problems with that. Okay, so what is the first wage and hour law that I want to highlight to you? The first one I want to highlight to you is what we call the work week. A work week in Massachusetts is any 7-day period that runs consecutively for payment purposes. That is your work week. A work week can be whatever 7 days you want it to be. So you could say it's Sunday to Saturday. That's common, right? Which means if I work on Sunday and I'm eligible for overtime, which we'll get into here in a bit, as long as anything I work between Sunday and the end of the day Saturday is considered to be work done for overtime purposes within that work week. Okay. Some employers say, I would rather the work week be Wednesday to Tuesday, Tuesday to Monday, Thursday to Wednesday, Friday to Thursday. It can be whatever you want it to be, right? You pick whichever works best for you, but once you pick it, you set it and forget it, right? So you would pick your work week, so it's whatever 7-day period you wish for that to be. Okay, now, as an employee, what else do you need to be mindful of? There is something in Massachusetts, a lot of people don't realize, it's called the day of rest law, which means all employees, as opposed to independent contractors, this doesn't apply to them. All employees must have no less than 1 day off for every 7 days of your so-called work week, right? So in that Sunday to Saturday work week, they'd have to have 1 day off. Now, I understand that you might say, hey, we're only open 5 days a week. We're only open 6 days a week. That's all well and good. But the point is that for pay purposes, the week is a 7-day period. It doesn't mean you have to be open all 7 days. It's just a finite 7-day period. And this is relevant when we get into briefly discussing when you have to pay the wages. Okay, so the first one is you have to have a defined work week of a 7-day period, whatever consecutive 7 days you want it to be. The next thing is all W-2 employees must have what's called a day of rest. Okay, now as far as the timing of paying W-2 employees, the law requires that you must pay all W-2 employees, with limited exceptions, either weekly or bi-weekly. Okay, now listen carefully, if I haven't put you to sleep already. if you pay weekly or bi-weekly, that is not twice a month. Semi-monthly or twice a month would be 24 pays. But if the Massachusetts law says it's either weekly, 52 pays, or bi-weekly, 26 pays, 26 pays, you do not meet the pay requirement if you pay on the 1st and the 15th of the month. Because, well, that may fly for a multinational company in other parts of the country. It doesn't fly in Massachusetts, because if you pay people on the 1st and the 15th, if you do the math, of course, what effectively is occurring? By giving them only 24 payments instead of 26, you're spreading out those extra 2 payments, albeit over the other 24 pays, right? Or over the 24 pays. But by delaying that, you're deferring some of their money, albeit a small amount, I get it, but you're deferring some of the money they should have been paid now by spreading it out over the 24 pays. As we'll get into in a while, there's a big gaffe and potential problem if you don't pay people what they are owed when they are owed it. Okay, so I've said employees, not independent contractors, employees must be paid weekly or bi-weekly. Okay, now, I already said the work week needs to be, it could be a Monday to Sunday, Sunday to Saturday. It could be 5 days a week, but it's within a 7-day snapshot of time. Why is this important? Because my next point is a W-2 employee, as you may or may not know, must be paid no later than 6 days following the close of the pay period. Now, again, if you follow the bouncing ball, let's assume that Monday of a given month is the first, June 1st is a Monday, and it's the first day of our 2-week pay period, right? So my work week, for purposes of calculating overtime, is, we'll call it Sunday to Saturday, even though our company didn't start work until Monday. All right, so the work week then ends, right, effectively on Saturday. Even though we only work Monday to Friday, the work week ends on Saturday, right, in theory. There might be overtime, or somebody might come in at certain times of the year on a Saturday. So that's the work week. I said a person must be paid no less often than weekly or bi-weekly, and they must be paid no later than 6 days following the close of the pay period. So if you pay every week, you would have to pay by next Friday, right, for the work week ending this Saturday. If you pay every 2 weeks, you'd have to pay by a week from Friday. I'm sorry, 2 weeks from now, for the work week ending, or the pay period ending a week from Saturday. So the pay period, the work week ends this Saturday, the pay period ends next Saturday, and the paycheck must be landing in the employee's hands no later than the following Friday. All of this is important. It is very dry, I get it, but it's all very important, because there's this penalty that you pay if you don't properly pay your workers. So you can see now with the buildup that a lot of employers have a lot of incentive to want to use independent contractors to be absolved of having to comply with all of these laws, right? Personnel file, onboarding, pay period, overtime, timing of the pay period, all of that is key. Now, people sometimes say to me, why do we get 6 days to make the pay after the pay period ends? And that's because that's been a legacy law. And years ago, when everything was done on paper, right, if you work for a mill or a factory, it would take the payroll department often 4 or 5 days to calculate what we owed you for the pay period that was just ending, especially if somebody's hourly paid, right? So that was a solid that was given to the employer to allow them to pay. Now, I've got people who will say, we pay every Saturday for the week ending the day before Friday. Is that okay? Of course it is. That would be, you pay weekly, and you're paying 1 day after the pay period ends, even though you have, the law allows you up to 6 days to do so. You've chosen to do it 1 day later. I've even got some clients who will pay employees on a Friday or a Saturday for work ending through that Friday or Saturday. Problem with that approach, in my opinion, is that some of those employers then will overpay people by mistake, because they didn't have enough time to calculate exactly what they were owed, and then future payments have to have adjustments made. So I would, whether you use a 1 week or a 2 week pay period, Most employers prefer to use a 2-week pay period because if they're using an outside payroll company, there's a per check processing fee. And if you're only processing checks every 2 weeks, it cuts in half your third-party payroll costs if you're paying some amount per direct deposit that is made for employees. Okay, so that's the 2-week pay period. So using my example of the work week or the work period starting on Monday the 1st, you would then have through Sunday the 14th would be effectively the end of the pay period, right? The 2-week pay period. And then you'd have to pay them by the 20th for the work done through the 1st through the 14th. Okay. Now, if again, I haven't scared you enough with all those concerns, what else do you need to do if people are W-2'd employees? Well, all W-2'd employees are entitled and must be covered by a workers' compensation policy. That is because any injuries they suffer at your workplace are covered by the Department of Industrial Accidents and the workers' compensation law. So you A, need to have a workers' comp policy, and B, you then need to have all of your employees covered by the workers' comp policy. There's an expense to that, right? Doesn't apply if somebody's an independent contractor. All W-2'd employees in Massachusetts must also have access to unemployment. All employers must make quarterly payments into unemployment based upon their payroll for the preceding quarter. There's a cost associated with that as well. Next, I mentioned the payroll. There is a cost of processing payroll. And part of the cost of processing payroll is deducting all usual and customary taxes and withholdings, right, for your W-2'd employees, which again is there's a payroll process, but then you've also got to collect the taxes and remit the taxes to the various agencies, the unemployment, federal government, state government, Department of Revenue, you have to collect those payments. So again, I'm pointing out all the reasons why there's an incentive, especially for small mom and pop businesses, to try to use independent contractors where possible, because they don't have to comply with all these laws. And we haven't even gotten to the biggest one yet. Okay, next. Hopefully most of you know about FICA taxes and what that is. Those are called like payroll taxes is frequently what they're called. And it's just under 16% of, and on top of federal tax, on top of state tax in Massachusetts, state income tax, we also have, and this is across the country, what we call FICA or Social Security taxes, which are just under 16%. Half of that tax, half of that 15 point something tax is paid by the employee out of his or her wages, right? The other half is out of the employer's operating funds. So by paying somebody as an independent contractor, if you think this through, if you're paying somebody $1,000 a week, right, you're going to save just under 8% per week and not having to make a FICA employer contribution towards that nearly 16% Social Security tax because you're not having to pay that. All right, next, what is another law that applies if you have somebody as an independent by an employee versus an independent contractor? Okay, and that is something known as the Massachusetts Earned Sick Leave Law. If you've got W-2'd employees and are not familiar with this law, I invite you to keep it in mind. Okay, July 1st of 2015, Massachusetts, a law became effective that said all employees in Massachusetts, regardless of their full or part-time status and regardless of the size of the business, must earn 1 hour off for every 30 hours worked, up to a maximum of 40 hours off, right? So if somebody works fewer than 25 hours a week, because I've done the math, they're going to run out of year before they ever got to 40 hours because they just didn't work enough hours to do so. Similarly, if somebody were to, it was a big season in the wintertime and you did snow plowing, somebody could conceivably have earned 30 of their hours all before June 30, right? That doesn't mean they can earn another 30. It caps at 40. So there are times when a person won't work enough hours to even get to the 40. And there will be times when somebody gets to the 40 very quickly, but that means once they've gotten to 40, they stop earning them. Okay. Those hours are paid if the employer has, it's either 10 or more or 11 or more employees. And if you have 10 or fewer or 9 or fewer, as it were, employees for your business, then you still have to give them the time off. It just doesn't have to be paid. Okay. Now, a quick thought about that I'll just mention to you. If you have W-2'd employees and you're already giving them sick time right now, paid or unpaid, if you're a big enough employer and it's unpaid, you need to make it paid, or you alternatively give them this PTO of 5 days per year, 10 days per year, use it for sick vacation or whatever, or you just say it's for vacation. You don't have to give them more sick time to comply with the law. The key is the law is a floor, and as long as you're giving a more generous benefit already, then you're compliant with this law as well. There are nuances about the accrual of time off and documenting that and what you can ask. I won't get into the weeds with that today. I'm just pointing out to you that if they're independent contractors, you don't have to give them any sick time or any vacation, but if they're W-2'd employees, you must. Okay, you don't have to give them vacation, but you must give them sick time. If you give them vacation, it can be backfilled to be used for both sick and vacation, if you're with me. Okay, now, another thing, there's something called the Mass Parental Leave Act law. Many people don't know about it, but it basically affords employees who have been with you a short time, at least a short time, an eligibility to take up to 8 weeks off, paid or unpaid. It's presumed to be unpaid, for the birth, adoption, foster care of a child. Now, for those of you who are familiar with the FMLA, for employers with 50 or more employees, it's an analogous law, and they would run concurrent. So that if you were entitled to both, if you work for a company with 80 people, you would get, or the employees would get, the 8 weeks of the Mass Parental Leave Act and the 12 weeks of the FMLA. And the first 8 would be both, and the last 4 would be the FMLA. If you're a small employer for whom the FMLA doesn't apply because you don't have 50 or more employees, then they would only get the 8 weeks. Another difference between this and the FMLA is FMLA requires that they have been working for you for a year before they can take the time, and they have to have worked 1,250 or more hours before they can take the time. Mass Parental Leave Act doesn't have an hour requirement. They just have to have been with you for a short period of time. Much shorter than a year. So I just invite you to keep that in mind. Moving right along, there is something called the Mass Paid Family and Medical Leave Act. You may have been familiar with that. That came into effect in January of 2021, where people can have up to 20 weeks off for themselves or up to 12 weeks off for a family member. Again, that law applies if they're W-2'd employees. It doesn't apply if they're independent contractors. Another law that they have to comply with if they're W-2'd employees, and keep in mind, folks, I'm pointing these things out because if you do have employees, you got to make sure you're complying with these laws already, right? So I'm teeing it up for you as to why these are important as the distinctions between independent contractor and employee. But my main purpose as well is to make sure you're compliant with these things. Okay. Another thing that, assuming you have W-2'd employees, that you have to comply with is what's called the Massachusetts meal break law. Massachusetts requires that any employee who works 6 or more hours or more than 6 hours in any given day must be given a paid or unpaid half-hour break during the day, and it's got to be an uninterrupted break. It can't be 5 times a day, 6 minutes apiece. It can't be 2 15-minute blocks. It's got to be one uninterrupted 30-minute block where the person is not expected to do any work. Now, it can be unpaid. If somebody is an hourly paid individual, it can be unpaid, and they should punch out and punch back in at the start and end of their meal break. If the employer insists that the employees remain on site during the meal break, which is their prerogative, the employees must be paid for the break because of the inability to go out and buy a sandwich or go for a walk or to drive around the neighborhood, right, or wherever the case may be. So it need not be paid unless you require the people to remain on site during their break. Now, I've had people say to me, we're working on a job site out in a rural part of the state. No, they know in a half hour they can't even get off the property, let alone get to somewhere, get a sandwich and get back. So they all bring their lunch and they all stay here. Do I have to pay them? The answer is no, as long as you're not requiring them to stay on site. If they're staying on site because of geographic limitations, that it's not possible to go somewhere else, that is not your issue. Finally, you need to comply again with all the OSHA workplace regulations with regard to W-2'd employees. Okay. And so I invite you to keep that in mind. Okay, so now, one of the things, so now what I want to do is I'm going to walk through with you what it means in Massachusetts, right? Because I've indicated why it is that a lot of employers would like to classify workers as independent contractors. I'm going to mention the biggest reason why, if the other reasons weren't reason enough. The biggest reason why is because W-2 employees who are paid hourly are eligible for time and 1/2 overtime for all hours worked in excess of 40. An independent contractor, you can set an hourly rate with him or her, and that hourly rate doesn't need to change whether they work 30 hours, 40 hours, or 50 hours, right? That would be the case. Now, I've got, at this point in when I make remarks like this or talk with clients, people will say, hey, I've got a workaround. I'll go to a temp agency or an employment agency and have them provide me with workers, right? A staffing company. And they will not be my independent contractor and they won't be my worker. I'll just be paying a vendor, a third-party vendor, an incorporated entity for their workers. And won't that absolve me of any of these requirements? At some level it will. And that's why you pay a premium for employees from a staffing agency. But here's where this could jam you up. I just tell you this horror story because this occurs occasionally, is if you're hiring people from a third-party employment agency, a staffing agency, to provide you people to make widgets on an assembly line. And you know that the minimum wage is $15 an hour, and you know that if you had workers doing this work at your as W-2 employees of yours, you would owe them time and 1/2 for hours worked over 40. If you have widget makers provided by a third-party entity and they say pay us $20 an hour for every hour they work, well, that's more than minimum wage, but it's not time and 1/2. And so if they work over 40 hours, I have seen employers, companies get jammed up because they get brought into a case when a suit is brought by the worker for the third-party staffing agency who said, look, the entity retaining my services should have known that I was not being properly paid because they were only paying $20 an hour for my first 40 and $20 an hour for my second 20 hours. I should have been, how could the employment agency or the staffing agency be paying me time and 1/2 for hours worked in excess of 40 if the end user of my services is only paying the staffing agency $20 an hour? If that makes sense. So it's a cautionary tale. If you ever use in a staffing agency to provide you workers, you want some assurance from them that they're making sure that these people are properly authorized to work for them and that they are being paid as W-2 employees of them, not as independent contractors of theirs, and that they are complying with all wage and hour laws to make sure those people are being properly paid overtime. Okay, so with that, I'll mention to you the independent contractor law. I've built it up now. Let's go through what the independent contractor law provides. So the independent contractor law in Massachusetts is found at Mass General Law, Chapter 149, Section 148, capital B, B as in Bartulis, my last name. Okay. Now, you just can't wave a wand and say, hey, guess what? I'll pay you. I won't take taxes out. I won't offer you health insurance. I won't offer you earned sick leave. I won't offer you a paid meal break. I'll pay you more. You worry about your taxes. I can put more money in your hand. What do you say? Well, a lot of people might like that arrangement and might agree to that. The key is that the state makes it very clear that whatever the two parties' intentions were, that doesn't control. So one party can't say when they get called out on this by the state, oh, well, we had an understanding. She wanted to be paid as an independent contractor, which she may very well have. The state says we've got to protect her from herself, and we've got to disincent you to go down the path with her of paying her as an independent contractor if these three prongs aren't met. And why does the state have a vested interest in that? Well, cynically, their main interest, of course, is getting tax revenue. If they're not getting state income tax from the individual because they're being paid by you as an independent contractor, a lot of taxes go unpaid because of improper classifications. Now, you may be saying to me at this point, well, what the government doesn't know won't hurt me, right? Well, that may be true in one sense, but here's what happens. The relationship with the independent contractor goes sideways, and then they run and they file for, guess what, unemployment. The Department of Unemployment Assistance reaches out to you as the entity retaining the independent contractor services, and they say, she's just applied for unemployment, but we don't have her down as an employee of yours. What's going on? You now have to explain to unemployment why you don't have her down as your employee. And when you say she was an independent contractor, unemployment is going to do a deep dive to determine whether she was properly classified as an independent contractor under the standard of MGL 149, 148B, or alternatively, whether she was misclassified as an independent contractor. So the issue about classifications, it really comes down to independent contractor versus employee is you can never go wrong classifying somebody as an employee, because even if they might have arguably been eligible to be an independent contractor, there's no fallout, there's no downside if you properly pay them as an employee. There may be more cost to you to do so, but you will not be found flat-footed by an improper classification. If you classify somebody as independent contractor and it's later determined that they didn't meet the three-part test that I'm going to walk you through, what happens then? What happens then is you owe a lot of money to a lot of people, and we'll get into that briefly. But okay, so what are the three prongs to be an independent contractor? The first one is that the person providing the services to you, and this can be found in MGL 149, section 148B. The person providing services to you is free from direction and control of you in asking them to do something. So an example I would give in the contracting trades is I would say, go frame that house. Go put that asphalt shingle roof on the house. I'm giving you a completed task to perform. I'm not telling you how to do it. The minute I tell you, follow me, I'm going to show you how to put the asphalt tiles on the roof. Now I'm directing and controlling what you do. If I tell you it's got to be between 8 and 2, you've got to start on the back of the building versus the front. I mean, every one of these cases is different, obviously, but the more you give them a wide berth to perform their duties, the more likely they would be an independent contractor. Now, I'm using the construction trades. I told you one potential workaround for independent contractors, if you don't want to pay FICA tax and payroll tax and all that, is to get them from a staffing agency, because now you're writing a check to a staffing agency, and as long as the staffing agency is incorporated, they're just a regular vendor, the same as National Grid or NSTAR or anybody else. You're writing a vendor check to a vendor. My only caution in the employment context is if you use a staffing agency, you want to make sure that they're paying their people properly. But assuming they are, that's one workaround, because you're not responsible for FICA and unemployment and workers' comp, sick days, paid breaks, all of that. Okay. The second workaround, and this dovetails in with my remarks now about somebody framing a house, is if I own a framing business and I do carpentry and I do framing, if I have Joe's Framing LLC, Joe's Framing Inc., Joe's Framing Corporation, well, now I'm not an independent contractor. I'm just like the staffing agency, a third-party incorporated vendor, right? So sometimes a light bulb goes off and people will say to a software developer, hey, call yourself Kurt Schilling LLC, and we can pay you as not as an independent contractor, but as an incorporated entity vendor, because as an incorporated entity vendor, that incorporated entity is supposed to be paying all of their corporate taxes, so the state is getting all of its taxes. And in theory, that employee or employees of that entity are supposed to have all the unemployment and FICA and workers' comp all taken out by that employer. Okay, so the first workaround is to use a staffing agency and incorporated business. The second one is to use a vendor who is itself incorporated. But let's assume it's just Joe's House Framing and I'm just a guy with a truck, and I'm not an incorporated entity and I want the check or cash paid directly to me. All right. Well, so the first one is freedom from direction and control. So let's assume that I'm over that hurdle. I make that hurdle. You're not telling me how to frame the house. You're just telling me to go do it. Okay, next, prong number 2. And by the way, all 3 prongs must be met or all bets are off and they can't be an independent contractor. Number 2, and this is the one where most people get jammed up. The entity retaining your services does not itself have any W-2'd employees providing that same service. Well, this is where most employers get jammed up. And I'll give you an example of this. What if I'm an accounting firm, Smith & Jones Accounting, LLC. I've got 15 accountants working for me in there. We all work together and we all do tax returns and everything else. But during the busy tax season, from New Year's to May 1st, the end of April, I bring on 6 other workers to sit in cubicles right near my employees to make up for all the extra work we have by virtue of it being tax season. Can I bring them in as independent contractors? You may not. Why? Because I've already got 15 other people doing taxes who are my W-2'd employees. I can't bring in John Smith off the street to be a temporary accountant for me because he doesn't, or she doesn't, if it's Susie Smith, doesn't meet prong 2, which is the employer doesn't have any workers doing this, right? So I'll give you an example of where people can get jammed up on this. Let's assume I'm trying to sell product door to door or house to house, whatever the case may be. And I've got 6 people doing this work as employees and 6 more who are doing it as independent contractors. One of those 6 has a falling out. They go file for unemployment. Unemployment says, why are they not recorded as one of your 6 employees? You actually have 6 more of them. That's really 12 workers. Why are those 6 not covered? Oh, well, they're independent contractors. Why are they being treated differently from the 6 you already have as W-2'd employees? Follow me? So some people, a light bulb goes off and says, well, what if I have no employees and they're all out bird dogging for work, house to house, whatever the case may be, chasing ambulances, whatever they may be doing, and none of them are my W-2'd employees? Well, I mean, that may be a possible, but the point is this: you can't commingle workers with others. So I can't have a crew of my own framers who work for Joe's Construction Co. working side by independent contractors who are just getting paid in their name to help pick up extra work to help us frame this large home. Okay. Prong 3. Prong 3 is that the worker who's working with freedom from direction and control, that's prong 1, who is providing a services that you have no W-2'd employees providing, prong 2. Prong 3 is they need to be in an independent trade, profession, or occupation. That prong is usually met pretty easily, not a tough hurdle to meet. The key for the 3rd prong, the reason the 3rd prong is there, is they don't want some employer getting creative and saying, I'm going to have all of you people working in the machine shop as being independent contractors as you stand next to the machine in our warehouse or our factory. You need to have an independent profession, trade, or occupation, which usually means, maybe you're an expert at floral design, maybe you're an expert painter, maybe you're an accountant, maybe you're an architect. The point is that you've got some special skill set beyond laborer. You should not have independent contractors mowing lawns, even if you have nobody who mows lawns for your company, because lawn mowing is not considered sufficiently skilled, right? I'm just picking on lawn mowing. It could be anything, you fill in the blank. So they would need, it avoids laborers being paid as 1099 individuals. Okay, now, having built all that up, the question then becomes, what happens if I improperly classify an independent contractor as somebody who should have been an employee as an independent contractor? What is the fallout? Another law that I want to point out to you is called MGL, Chapter 149, Section 148. That is called the Massachusetts Wage Act. Doesn't say it on the section, but that's what it's referred to commonly. Under the Massachusetts Wage Act, I mentioned to you there are a whole host of laws about how often you pay people, the pay week, and if they're and all these other things. If you have an independent contractor, you haven't taken taxes out, you haven't done a lot of these things, you haven't given them a meal break. There is a group at the Massachusetts AG's office called the Fair Labor Division. It's a division at the AG's office, just one of many. They're the ones who oversee the application of the Mass Wage Act. If you do not properly classify people correctly, let's assume you have an independent contractor who worked 50 hours a week and you paid her $25 an hour, right? So you paid her over minimum wage and you paid her 25 bucks an hour. She later, 8 months into your relationship, she says, this isn't working out. She quits and runs and files for unemployment. Or if you terminate her, she leaves, she files for unemployment. Now you're jammed up at unemployment, right, with the Department of Unemployment Assistance on this whole issue about is she or is she not eligible for unemployment? If she was an employee, she would be. Because you didn't classify her as one, now you might owe penalties to the unemployment. Okay, but next, she goes to the Fair Labor Division at the AG's office and files what's known as a failure to pay wages claim. And she claims, I was paid 50 hours at 25 bucks a week, no problem there. And he paid me religiously every 2 weeks, or not every 2 weeks, once a month. But I really think I should have been an employee. And I didn't get my paid earned sick days, or I didn't get my earned sick days. And I took days off that the company's large enough that those should have been paid. They didn't pay into unemployment. They didn't take taxes out of my wages. But here's the big one, Your Honor. As an hourly paid employee, I was paid by the hour, 25 bucks an hour. Hours 40 through 50 should have been paid at time and 1/2 $25 an hour, right? And now all of a sudden it's what, $37.50 that they should have been paid. She's been working for you 8 months. She's worked 50 hours a week every week for 8 months. And now she wants the extra $12.50 per hour that she didn't get for the extra 10 hours she worked every week for the last 8 months. Ouch, that hurts. But it gets worse. Under the mass wage law, I said every employee must be paid what they are owed when it is due to them. It is due to them every week or every 2 weeks, depending on whether it's a weekly or a bi-weekly pay period. You say, well, that doesn't apply to me. She wasn't my employee. Yes, but she should have been. So now the question is, because you didn't pay her in the 2-week payroll period, first of all, you didn't pay her every 2 weeks. That's a gaffe, and there could be a citation for not doing that. But then the next gaffe is that you don't owe her now just $12.50 for the extra hours, right? The extra half time for the extra 10 hours. The penalty, are you sitting down, is triple damages. So now you owe her $37.50, whatever it is, right? $12.50 times 3 for 8 months. Every week for every hour for 8 months. All of a sudden you're owing 36 bucks plus per hour, right? $37.50 per hour, because it's trebled for every hour worked over 40 for the last 8 months. If she's been with you 2 years, it goes back 2 years. The look back can be up to 3 years. You can see why this gets very costly very quickly. So my cautionary tale to you is, while it is attractive to use independent contractors, if the relationship goes sideways and they either get hurt at your workplace, they file for unemployment, or they just file a claim with the AG's office, you can see how this gets very costly very quickly, especially if you've got more than just one independent contractor. Now, if you say to me, well, she only works 40 hours a week, and I do pay her every 2 weeks as an independent contractor, you would still owe taxes, unemployment would have to be made whole, and workers' comp would, but the overtime component, which is the most expensive component of all, you've avoided. But many times people try to get around time and a half by paying an independent contractor a straight rate because they don't want to pay them as an independent as an employee. Okay, now with regard to the FICA, I told you it's about 16%, just under that, and the employer and the employee pay half each. If it's later determined that this independent contractor should have been your employee, you're not responsible for her federal tax, you're not responsible for her state income tax, but you will, as a penalty, be responsible most often for paying both the employer and the employee portion of the FICA tax. So your cost of just 7.5 0.75 or whatever it is, whatever your half is of that, just under 16%, now you're paying both parties part. So you're now paying additional almost 8% penalty on top of all the other things you're having to do because you didn't properly classify the person. So again, my cautionary tale is be very careful, read the statute. There are some AG advisories out there that speak to this whole thing about independent contractor, and there's some Massachusetts AG advisories on what it means to be an independent contractor. But I just point that out to you that those are some of the pitfalls. This was dry material, but I wanted to cover it. So in the remaining time I have, I've scared you into calling people employees, right? So now the question is, Joe, you scared us by saying time and a half for time over 40. Well, even if they're your W-2 employees, you have to pay time and a half over 40, right? For all hours worked over 40 for an employee who is classified as hourly. There is a federal law called the Fair Labor Standards Act. It goes by the moniker FLSA. The FLSA basically stands for the proposition, it's a federal law, that all of us are entitled to be paid overtime for all hours worked over 40. That's the default, that's the rule as it originally existed. But then they came up and they said you can be exempt from the law, and a worker can be exempt from the law if he or she is salaried. Well, this is a similar gaffe that can occur, right? Misclassifying somebody as salaried versus hourly. It's all the same issues that are attendant to the independent contractor, at least as it relates to overtime. That's where this one really comes up. Because if they're a W-2 employee, you're already going to pay them, earn sick time, meal breaks, all that. So you're compliant with all those things. So you're much better off than the independent contractor. But if you classify somebody out of convenience to be salaried or exempt meaning exempt from the application of the Fair Labor Standards Act, and you're later determined that you've misclassified somebody as exempt versus hourly paid, you get into that same issue of all the hours worked over 40 that the person should have been paid at time and 1/2, but they weren't because they got a salary. You understand that a salary is, I'm going to pay you $1,000 a week, whether you work 38 hours a week, 40 hours a week, or 60 hours a week, you get the same $1,000. If somebody meets the criteria to be an exempt employee, that's okay, because it all comes out in the wash in theory, because there might be a week when they only work 35 hours, but they're getting their $1,000 because they, in theory, have stockpiled extra hours, goodwill, by working beyond their regular work week on other weeks. So the theory is that a salaried individual is not eligible for overtime and need not be paid overtime. But because you're saving the overtime costs, you need to make sure you properly classified them as exempt salaried, and you didn't just do it out of convenience. So without further ado, I'm going to briefly just tee up for you. It's not a heavy lift, and I'm going to tell you where you can find some good information on this. The U.S. Department of Labor has what they call the Wage and Hour Division. In Massachusetts, it's the Fair Labor Division at the AG's office, but federally, it's the U.S. Department of Labor Wage and Hour Division. They have these things called fact sheets. And they have fact sheets. They're around the number 17, fact sheet 17, fact sheet 18, fact sheet 19. But those basically enumerate in great detail for you what it means to be paid overtime. I'm sorry, what it means to be exempt versus non-exempt. Okay, so I would invite you to look at those, but big picture, to be an exempt employee, you need to meet two criteria, or one needs to meet two criteria. The first criteria that they need to meet is what's called the salary basis test. And that means that their weekly salary every week, not subject to up or down, is no less than $684 a week. So if you're paying somebody less than $684, they can't be salaried no matter what their duties are, because you're not paying them enough money. Most everybody in Massachusetts who you would want to classify as salaried is making at least $684 a week. Okay, next, they need to meet what's called the duties test under the FLSA for an exempt salaried position. So what are the duties? Well, it depends on which exemption applies. There were really three primary exemptions, two that come into fold for most businesses. The first one is called the executive exemption. The second one is called the administrative exemption. A third one is called the professional exemption. And the fourth one is called the outside sales exemption. Now, the interesting thing about the outside sales exemption is you don't even need to pay that person $684 if they are truly outside sales. They don't even come into your workplace. They're out in the countryside applying their trade. We don't need to get into the minutia of that. It's far more detailed than we have time today to get into. But assuming you're paying your person $684, so you're over that hurdle, and now you're saying, can I pay her as an exempt salaried person who gets the same salary every week and does not get paid time and a half overtime for hours worked beyond 40? What happens then? The duties test for executive, okay. The duties test for executive, and I'm just going to look at my notes here to make sure, is that they customarily and regularly direct 2 or more employees, that they have the ability to hire and fire employees, and that they get to be involved in the decision of regarding employees' promotions, wages, demotions, those kind of things, right? They effectively run the business. Oh, and by the way, our salaried individuals can never be doing manual labor, right? It's always got to be some kind of like a white collar job, an office work, right? But assuming that they're managed 2 or more people and they have a say in hiring and firing and the like, and they make $684 a week or more, that would be the executive exemption. The administrative exemption doesn't require that the person oversee 2 individuals or weigh in on their disciplining or promoting or the like. What that requires is that the individual exercises, quote, independent judgment on matters of significance of the employer. So again, you'll want to look at the fact sheets to compare and contrast because they go into detail about what it means to exercise independent judgment. But if I'm the receptionist or the person who answers the phone inside the office and I make over $684 a week, I meet the salary test and I'm meeting the non-manual labor test. But guess what? Answering the phone is not, and scheduling appointments is not exercising independent control over an important aspect of the business. The professional exemption, kind of finishing with that, the professional exemption, again, is $684 per more or week, and the person is doing something that requires a specialized degree of education and often licensure, right? Lawyer, doctor, architect, engineer, whatever the person might be, they have specialized skills. Now, might one argue that a barber or a stylist might have a license? They have a license, yes, but they're doing manual labor. They're cutting hair, you see. So that's why those trades usually don't apply for that. If it's determined that you paid somebody $1,000 a week and she worked 50 hours a week as your W-2 employee, all the parts about earned sick leave, all of that, you're compliant with that. Unemployment, you're compliant. Workers' comp, you're compliant, but you still are vulnerable, right, for up to 3-year look back for not properly paying her what she was owed, when she was owed it, at the time and a half. Using the $25 example, she's entitled to $12.50 more per hour times 3 for however long this has been applicable. So my purpose today was to kind of put the fear of God in you and make sure that you, the takeaway for you as we wrap up now, the takeaway for you today is this. If you're at all concerned that somebody should not be an independent contractor, use your best instincts, classify them as an employee. You can't go wrong with that. If they're an employee and you're on the fence as to whether they could be exempt salaried or they should be paid hourly, default to the safety, which is paying them hourly. You can never go wrong, right? And that should be your guide, because I don't want to see you get jammed up and have to pay treble damages on the law. I will leave you with this. There was a case from April of 2022 called the Reuters, like the news service. A woman named Reuters worked for the city of Methuen. And what the law had said for a while, so if you've heard this, this is no longer good law. But the law had said, look, I know I owe them triple damages. That's what the law says. But if I run to make a payment to you for the $12.50 per hour that I should have, and I get that check in your hand before you sue us, is that a workaround that gets us to a safe place that I don't have to pay the treble damages? In the past, you beat them to the courthouse by paying them. Now their case is mooted, and you can't get treble damages unless you get it from a court. The court is the only one who can issue the treble damages. Ms. Reuters said that seems unfair. They should have paid me my 3 weeks of vacation. Now they owe me 9 weeks of vacation, treble damages. The fact that they caught it before I filed suit doesn't change the fact that they didn't pay me when it was owed, which was her last day of work, right? It's owed on, if you terminate them, the last day they work for you, or the next pay period if they quit, in this example that applies to her. In that case, they didn't do so, and the court found that she was entitled to treble damages. So here's the key. Pay people what they are owed when they owed it, and if you later find out you made a mistake, pay them, correct the mistake as quickly as possible, but the payment to correct the mistake may no longer be the cure-all that people might have thought it was prior to this Reuters decision. I'm happy to stay on if anybody has any questions. 3, 2, 1, you're now waking up. And I, again, thank you all for being involved in listening to this dense and dry material, admittedly, but hopefully you learned something valuable. Thank you all. I think you're muted.
Now I'm not. Okay, so thank you so much. Very informative, dry, but really important, really important. You don't want to get caught up in any of these scenarios. We did have a couple of questions, and it has to do with fixing mistakes. So someone maybe attended today, starts thinking about the independent contractors that they have and says, ooh, they really should be employees. Now, how do we fix that? Do we go back through, you know?
Well, so there are two answers, right? There's the so-called belt and suspenders answer, which is the one that ensures that someone's pants don't fall down. Is yes, if the person's worked for you for 6 months and you say in hindsight they should have been my employee or they should have been hourly paid rather than salaried, in a perfect world you'd go back and correct all those things and make them whole, right? Recharacterize them. If that becomes unworkable for whatever reason, and this is not the best approach, but it is not an unusual approach, is people say, I'm going to start fresh today. I'm going to correct it today. I'm going to onboard her today as my W-2 employee, and go from there and hope that that just resolves the issue going forward. The problem that comes from that, and I don't have the answer, is people will say, wait a minute, why are you changing me to an employee now? I don't want to be an employee. I'm used to having all this money in my check, and now I'm going to get it with all these taxes taken out. And they have an epiphany. Oh, wait, so I should have been an employee all along. And now all of a sudden it's, wait a minute, I worked all those hours over 40. So you're kind of damned if you do, damned if you don't. You always want to remedy the problem as quickly as possible. And in the perfect world, you'd go retroactive as far back as need be. The look back on most of these things is 3 years. So if somebody worked for you for 5 years as an independent contractor, you wouldn't have to go back beyond the statute of limitations in any event. But let's assume they work for you for 6 months. In a perfect world, you would go back to 6 months. By converting them to an employee, one, they may not like that arrangement because now they're getting less money. But two, if you've had them work over 40 hours, you're now vulnerable to this whole treble damages case, but you're damned if you do, damned if you don't. If you go blindly keeping it the way it is, every day you keep doing what you shouldn't be doing is another day you're susceptible to a problem, right? If you resolve the issue and bring them, even if you only make the conversion now and don't do anything retroactively, which would not be my suggestion, but if that's what you decided to do, remember the look back is usually only 3 years on most of these things, 2 years in some instances. So for every day after you've corrected that you dodge a bullet where the person doesn't come after you, right? That's one less day of retroactivity if they've been with you 3 years, because now it's 3 years less 1 day, 3 years less 1 day. So the look back gets shortened with every day that you've properly paid them. Similarly, if you had somebody who left your employee a year ago, and they left your employee a year ago and only worked for you a year, well, now they're really, the look back for them would only be the year that they worked for you, and they're already, a year behind on that, right? They've already lost 1 year of the retroactivity. So they still could bring a claim within the next year or two against you. But with every passing day, that becomes less likely, right?
Right. Okay. Very helpful. And then a question about the PTO versus sick time and vacation time. So just a little clarification there. Some companies pay, just have a PTO policy that encompasses both.
Yes. Okay. So real quickly, and again, dry material as it is, there is no requirement in Massachusetts that any employer give any employees vacation time. There is no requirement on that. That may not be a place that people want to work. They may have trouble getting employees, but there's no law that requires people getting vacation time, paid or unpaid. Because some employers didn't give vacation time, other employers didn't even give sick time. So they didn't get sick or vacation. So what the law is they came in, Massachusetts, effective July 1st of 2015, came out with a law that said, going forward, you need to give people the ability to earn sick time. We're not going to force you to do anything for vacation. So for employers who already gave sick time, not a heavy lift, they were already compliant. For employers who gave vacation without sick, which is rare, right? Because you're not going to give vacation instead of sick. They were compliant as long as those days could be used for sick. If an employer gave one bucket of time called PTO, right? I say 2 buckets, vacation and sick, 1 bucket PTO when you've commingled them. When you've commingled them, the same rule applies as long as they're getting access to no less than 1 hour off for every 30 worked, up to a minimum of 40 hours. You may give them 80 hours, but a minimum of 40, you're compliant with the law as well. The only time you could get jammed up is if you say we only give it on a once every 2-month basis, you earn it, or once every quarter, right? Then conceivably they're accruing it at a rate, the number of days is greater than needed, but the rate of accrual is slower than needed, right? So somebody could be out in Q2 and not have access to time they would have otherwise had if they were getting it 1 hour for every 30, because they're getting it quarterly. So I won't get into the weeds with you, but the takeaway is this: if you presently offer PTO or you offer vacation and sick, the only key is that collectively the time off that you give them, paid or unpaid, depending on the size of your business, must be no less generous than 1 hour off for every 30 worked, up to a maximum of 40 hours. Now, under the earned sick leave law, you can also carry up to 40 hours from 1 year into the next if you never use them. But then the law is clear that I don't have to allow anybody to accrue new time off until they have access to 40 hours. If you carried all 40 over, you're not earning 1 hour for every 30 worked this year, right? Because you have stockpiled 40 from last year. You got to draw some of last year's down before you can start earning more for this year.
Okay. Just to be more confusing, right?
Yeah.
And then finally, we've hired a staffing agency, and this is the scenario of paying $20 an hour and having some exposure because you're not paying overtime. But that $20, we don't know how much of that $20 actually goes to the employee. So could it possibly be enough to cover?
Well, no, it couldn't, and I'll tell you why. Because if you're paying 20 bucks an hour, Mass minimum wage is 15. So if they're working in Mass and it's a Mass agency, the employee has to, or the worker bee provided to you by the temp agency, needs to be paying that person the same $15 an hour that you'd need to be paying them. You're paying them 20 bucks an hour, so all is good, because you know intellectually that the person is earning at least $15 an hour. There's other issues that are beyond you that we need not worry about if the temp agency is not giving them the full minimum wage. But if the temp agency is taking $5 off the top so that they're getting 15, the employee is of theirs, and they're getting 5, all is fine for the first 40 hours. But if they work for the staffing agency and they start working for you for more than 40 hours, if you're only paying the staffing agency 20 bucks an hour, and the staffing agency is obligated to pay the person $22.50 or whatever the amount would be, there's no way that the staffing agency can remain in business, cover its operational costs, and pay the worker bee $22.50 an hour when they're only taking in 20 from you.
Okay.
And this happened, I don't know which casino it was, but I believe down in Connecticut, they had hired a temp agency to provide workers at one or more of the casinos. And what happened was the temp agency was not charging them a premium for hours worked over 40, and the casino was like, not my problem, right? But then the court said, no, you should have known better. You should have ensured that they were properly paying their workers, just as you would have had to properly pay them, so too do they.
Okay. All right. Well, I don't see any other questions. I just wanted to remind everyone that we've recorded this and we'll be sharing it with all of the registrants of the session today. And thank you again to Joe Bartulis. This is really, really important information. And any final words, Joe?
No, only to thank all of you who sat through and endured my remarks. I very much appreciate it. If anybody has any questions, they can reach me at Fletcher Tilton. My number is 508-459-8214. My email address is the first letter of my first name, the letter J, followed immediately by my last name spelled Bartulis at Fletcher, like it sounds, FLETCHER, Tilton, TILTON.com. Thank you all.
Okay, thank you.
Have a good day.